Hello and welcome everyone to your channel Lawpedia, and this is me Jasmine. So in this particular video we will be covering what is the law aspect जब हम बात कर रहे हैं of domestic violence. Also, according to India's National Family Health Survey, an exhaustive household government survey from 2015 to 2016, around 33% of women have experienced spousal violence in terms of physical, sexual, or emotional nature. And out of these 33%, only 14% हैं जिन्होंने help seek करी थी. And almost 77% never spoke about it. So the majority of women who were experiencing any form of violence, whether physical, sexual, or emotional, actually did not speak about it only. And among those who sought help, 65% reported to their natal family and only 3% reported to the police. So this is a very important statistics जो यहाँ पे हमें ये बताता है कि majority of women experiencing violence in any form actually do not report the situation. First they try to reconcile the conflict in the household itself, and अगर वो report भी करना चाहती हैं, so according to the statistics they first talk with the family itself rather than going to the police. They feel more secure, safe and secure talking to the family members or talking to any person related to them according to the statistics. So that's the current scenario. Let's move forward. So section 498A of the Penal Code 1860, which provides for husband or relative of husband of woman subjecting her to cruelty. So this is a penal provision under which you could seek relief in case husband or the husband's family अगर आपको subject कर रहे हैं cruelty से. But another act was formulated, Protection of Women from Domestic Violence Act 2005, which we'll be seeing in this particular video. So basic factor, what are the objectives of the act? Objective of the act is to provide more effective protection of the rights of women guaranteed under the constitution who are victims of violence of any kind occurring within the family and for matters connected therewith. Also to grant statutory protection to victims of violence in the domestic sector. I'll be putting down the act in the description for you to read as well. Now quickly moving on to what is domestic violence. So before actually filing a complaint or before actually understanding that whether you are being subjected to domestic violence or not, आपको पता होना चाहिए what is domestic violence. Now if you read the act, under section 3 of the act, it defines what is domestic violence. And according to the act itself, if you read, आपको पता लगेगा कि domestic violence is a broad term that includes not only physical beating but also other forms of violence such as emotional violence, mental violence, sexual violence, financial violence, and other forms of cruelty that may occur within a household. And अगर आप definition पढ़ेंगे, you'll understand verbal and emotional abuse have also been included under the ambit of domestic violence. And verbal and emotional abuse जैसे insults, humiliation, name calling, anything which is done to the aggrieved person which actually humiliates the person would also be included in domestic violence. Also, repeated threats to cause physical pain to any person would also be categorized as domestic violence. Now, economic abuse का aspect भी आपका include होगा as per the act. Now, what is economic abuse? Economic abuse basically means depriving the person of all or any of the economic or financial resources to which the person is entitled. So, moving forward, now we'll understand the who factor. Who is an aggrieved person? So according to section 2A, an aggrieved person means any woman who is or has been in a domestic relation with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. Therefore, any woman who is or has been in a domestic relation is entitled to make a complaint invoking the provisions of the act. We'll just be knowing and understanding कि respondent term में कौन कौन included होगा. Firstly, we'll understand that what is a domestic relation, because since you can only seek relief against those with whom you are in a domestic relation, हमें ये समझना पड़ेगा कि domestic relation क्या होता है. So according to the act, the domestic relation may be formed in two ways, namely the marriage and the blood. So section 2F of the Domestic Violence Act implies that domestic relationship means a relationship between two persons living in a shared household. So now domestic relation can be through marriage, such as wives, daughter-in-law, sister-in-law, widow and any other member of the family, और ये ब्लड रिलेशनशिप भी हो सकते हैं जैसे कि मदर, सिस्टर or daughters and any other domestic relationship including through adoption, live-in relationship and the women in bigamous relationship or victims of legally invalid marriage. So ये इतना broad definition दिया गया है as per the act that firstly certain relations you create according to marriage वो तो included होंगे ही होंगे as well as every other aspect who can probably live in a domestic relationship would also be included. So any violence any person does against these stated individuals would bring them to be liable under the Domestic Violence Act. So domestic violence में सिर्फ wives या सिर्फ daughter-in-law include नहीं होती, उनमें blood relations such as mother, sister, daughter and any other domestic relation through adoption भी include होगा. Now, what is a shared household? So we are understanding these definitions because when you are trying to prove a domestic violence case, you have to show that there is a domestic relation. You have to show that there was a shared household, and when you want to seek your right to reside in a shared household, all the more आपको पता होना चाहिए कि what is a shared household. Now, according to section 2S of the act, a shared household is where the aggrieved person or a woman lives in a domestic relationship either singly or along with the man against whom the complaint is filed. It may also imply a household where a woman has lived in the domestic relationship but has been thrown out. So ये basically वो households भी include करेगा जहाँ पे woman in a domestic relationship रहती थी but with the domestic violence and all she was thrown out. So section 2S of the act is shared household. Now understanding other important aspect. Now act ये भी कहता है that whether the household is owned by the respondent or it is rented accommodation, still it will be included in shared household. And इसका क्या मतलब है कि women can seek her right to reside in a shared household despite the fact कि वो एक rented accommodation है. So let's say एक रेंटेड अकोमोडेशन है, वहां से आपको निकाल दिया जाता है, बट स्टिल यू वांट टू गो एंड लिव देयर, you can seek your right to reside in the shared household even against a rented accommodation. Now, the Domestic Violence Act recognizes women's right to reside in a shared household, जैसे कि मैंने पहले ही डिस्कस कर लिया है. This means that a woman cannot be thrown out of such a household except through the procedure established by law. And in case if a woman is thrown out of such shared household, she can obtain an order from the court to exercise her right to reside in the shared household. And उसको क्या establish करना होगा इस particular scenario में? Firstly, कि एक domestic relationship था, and secondly, एक shared household था from which she was thrown out. Filing a complaint of domestic violence. The woman, in order to file a complaint for domestic violence, may approach the police station and register the complaint. File a complaint to the protection officer or the service provider. So now the protection officer or service provider आपके act में ही stated है कि ये कौन होते हैं, generally established or generally registered or functioning under the state itself. Or the woman may directly approach the magistrate. So these are the three relief or three pathways one can adopt in case the person wants to file a complaint of domestic violence. Quickly moving on to the relief aspect. So now अगर आप understand कर रहे हैं the domestic violence aspect, what is domestic violence, shared household, etc., you must know what are the reliefs you can seek as per the act. Section 18 क्या कहता है? if the magistrate in such scenario is satisfied कि domestic violence हुआ है, so magistrate क्या करेगा? Magistrate may pass in such a scenario an order in favor of the woman and prohibit the respondent from committing any act of domestic violence, entering the place of employment of the person, attempting to communicate in any form. तो communication stop कर सकता है court. And इस case में court can also prohibit the respondent from alienating any assets such as operating bank lockers or bank accounts used or held jointly by both the parties. So in such case, that can also be prohibited by the court. Now, second relief that may be granted is the residence order section 19. सिमिलरली अगर मैजिस्ट्रेट सेटिस्फाइड है कि डोमेस्टिक वायलेंस हुआ है, सो मैजिस्ट्रेट सेक्शन 19 के अंदर रिस्ट्रेन कर सकता है रिस्पोंडेंट्स को फ्रॉम डिस्पोजिंग or disturbing the possession of the aggrieved person from shared household. And court may even direct the respondent to remove himself from the shared household. So if there is a domestic violence, court may say कि आप problem को वहां से हटाइए residence order के अंदर. According to section 20, monetary relief can be granted. So magistrate may direct the respondent to pay monetary relief to meet the expenses incurred and losses suffered by the aggrieved person or the woman and any child that may be there in that particular scenario. So monetary relief भी दे सकता है कोर्ट. कोई भी loss of earning हुई है आपको because of the domestic violence itself, medical expenses incur हुए हैं, loss caused due to destruction, damage, removal of any property, इसकी भी monetary relief court can grant to the aggrieved person. Now, section 21, custody orders. So, magistrate may at any stage of hearing of the application for the protection order or for any other relief under this act, magistrate grant कर सकता है temporary custody of any child or children to the aggrieved person or the person making application on her behalf. Now, section 22, compensation order. So, in addition to other reliefs as may be granted, magistrate एक एप्लीकेशन पे जो कि एग्रीव पर्सन मूव करेगा, मैजिस्ट्रेट ये भी ऑर्डर पास कर सकता है that the respondent have to pay compensation and damages for the injuries including mental torture and emotional distress. So apart from the other relief, आप further compensation भी seek कर सकते हैं अगर आप application move करें and the magistrate is satisfied with that. Now, section 23, magistrate's power to grant interim relief and ex parte orders. According to the case, if the magistrate deems fit, वो कोई भी interim order pass कर सकते हैं suitable. And if the magistrate is satisfied that the application जो भी file की जाएगी by the aggrieved person or the woman, वो primarily ये दिखाती है that the respondent or the husband has committed the act of domestic violence. So, court ex parte orders भी pass कर सकती है, that means without the other party, on the basis of affidavit in such form as may be prescribed. Finishing this particular video with certain interesting aspects that you must note that remedies under the Domestic Violence Act are available even against a female member and also against a non-adult member. Now, a breach of the protection order or an interim protection order by the respondent shall be an offense under this act and shall be punishable with imprisonment of either description for a term which may extend to 1 year or with fine which may extend to 20,000 rupees. Now, service provider कौन होंगे? NGOs, companies, voluntary organizations working in the field of domestic violence, and these are duty bound to provide assistance and support to women facing the domestic violence. With this, we come to the end of our today's video, and until the next video, as we always say, stay home, stay safe, and keep learning.